we tell our clients is custody cases and divorce cases all pretty much follow the same 5 steps. That's filing the case, going to temporary orders, discovery, mediation, and then trial. So the filing stage is whenever you file the lawsuit. A divorce, a child custody case, it's a lawsuit. So what happens is we draft up the petition for divorce or petition to establish the parent-child relationship or to modify a court order. We file that with the district clerk. The district clerk puts a stamp on it, gives it back to us, and then we have what's called citation issue.
So at Walters Gilbreth, we're real careful with our filing because it's really important to get it correct. We draw up things from a basic form so that we get the basic structure correct. We make sure we personalize it to that particular lawsuit, and then we also have one of our managing partners review it, either Jake or myself, to make sure that it's done correctly before it's filed.
There are a number of different ways that divorces can be filed. They can be filed very simply when you're expecting an agreement, or they may just be mailed to the opposing party. Again, expecting an agreement, but you can actually have the other party served when you think they might delay conceivably. But for many people, for a lot of our clients, they may need the protection of the divorce court while the divorce is going on. They may not be getting support. They may need to protect their children. They may need to protect their assets. So they can also be filed with a request for temporary hearing and quite frequently getting immediate orders that may protect children and property.
So temporary orders are probably the most important part of a case as far as predicting the way it's going to turn out.
In temporary orders, a judge decides kind of what the law of the land is going to be while the lawsuit is pending.
Temporary orders are really just a way of the court setting the ground rules that will be in place while your divorce is pending.
Whether that means child custody rules or conservatorship, financial, child support, or otherwise. It's really an important thing to get right, and it comes really quickly at the beginning of a case, sometimes as early as a week into a case. It's really important to be ready for that.
So if it's a divorce, a judge is going to decide who lives in the house. What are we going to do with the kids while the divorce is pending? How are bills going to get paid? How are attorneys going to get paid? How are we going to appraise property? All that's going to get decided by a judge in temporary orders. In a custody case, even if there's not a divorce pending, same thing happens. A judge decides what's going to happen with the children while the case is pending.
Discovery is a way of accomplishing a couple goals. One, you want to find out the information you need to be able to settle your case or try it.
In a divorce, a lot of times we're exchanging bank statements, we're exchanging financial records. If there's valuation issues, we're exchanging documents that experts need to value the businesses or value the real estate or the houses or what have you. It's also an opportunity to ask the other side what their position is on the lawsuit.
Are they going to contest custody? What do they think is a fair division of the estate if there's a dispute over the value of things?
And the idea is that if everybody knows what's out there and what's going on, that reasonable people will be able to settle their lawsuits. And that's how you try to get to that point.
Mediation is a process where the attorneys and the clients sit down and try to resolve the case. A mediator will be involved in the mediation. What this means is there will be a neutral third party that will go between the two sides and help both sides try to resolve their differences.
Mediations typically are a day long. In most of the more complex cases, they can be 2 days long. Mediation is simply assisted settlement.
Mediation is where somewhere between 80 to 90% of all cases end. Most of the time, people who are not that difficult of cases can settle their cases at a mediation.
I would say a lot of our cases resolve in mediation. That's always the goal, is to work out your differences. But you've got to be prepared that if the case doesn't resolve in mediation, you're going to have to be ready to go to trial.
Well, hopefully for most people, trial won't be necessary. But it's my philosophy that to achieve peace, you frequently have to prepare for war.
So the trial phase, which less than 10% of all cases get to, is really the most difficult and challenging thing that a lawyer does.
So anytime parties aren't able to work out their differences amongst themselves or amongst their lawyers, a judge or a jury is going to have to decide the controversy. What this means is that the parties will go to what we call a final trial.
Frankly, a lot of lawyers just don't try cases or barely ever try cases because it's very nerve-wracking. It's something we do a lot of here. Jake and myself are really comfortable with the trial process.
It's important to hire a law firm like ours that knows what's going to happen at the courtroom, that knows what a judge is going to do, that knows what a jury is going to do, and can give you that advice so you can take that information and decide whether or not it's best to settle your case or to go to the courthouse. We tell people to think about these 5 steps because it keeps us focused and keeps us accountable to move the case forward. We divide it into 5 steps so our clients know what's happening and they can be there with us every step of the way and make informed decisions about their case.